Hello aspirants, please subscribe to my channel to get all the dictations of the latest judgments of High Courts and Supreme Court. 5 seconds from now. By this common order, it is proposed to decide the aforementioned 3 applications, all of which have been filed under Order 39 Rule 2A read with Section 151 of the Code of Civil Procedure and the provisions of the Contempt of Courts Act 1971 for initiating contempt proceedings against the respondents for the willful and deliberate disobedience of the orders of this court during the pendency of the aforesaid suit. Before dealing with the merits of the applications, it is proposed to delineate the background in which the aforesaid applications were filed one after the other by the plaintiff. A suit under the provisions of order. The argument of senior counsel Mr. Pradeep Diwan that if no interim order is in force, there can be no disobedience of the same, whether willful or not, undeniably is a forceful one, and as pointed out by senior counsel has been the subject matter of various decisions of this court and of the Honorable Supreme Court. The pertinent question, however, is did the respondents flout an existing order of the court which was in force on the date when the alleged defiance took place? Thus viewed, the defendant or respondent number 1 cannot be said to have fallen foul of the order dated 17th August 2006, as the said order was undeniably not in existence on 16th November 2006 when the agreement to sell was executed, the suit having been dismissed for default of appearance a day prior thereto, that is on 15th November 2006, and eventually having been restored on 20th November 2006. The respondent number 1, there is reason to presume, was fully aware of the fact that the suit and interim orders would be restored, yet chose to transact the property immediately, and in fact on the very next day of the dismissal of the suit, taking advantage of its dismissal. Technically speaking, however, no contempt was committed by the defendant or respondent number 1 thus far, but from here onwards, the saga of the contumacious conduct of the defendant or respondent number 1 is clearly evident from the record itself. In the entire application, the para under reply is only relevant qua the non-applicants, as certain allegations are made against him. The statements made under paras under reply are vehemently denied. It is denied that the sole defendant in the suit has anything to do with the present non-applicants. At no point of time any restraint order of any kind was ever passed against the non-applicants, and the order alleged to have been violated too was not against the non-applicants, nor the said order was ever communicated to them. So far as the agreement to sell dated 16th November 2006 is concerned, it is matter of record that on that particular day when the document was executed, there was no order operating against either the sole defendant or against the non-applicants. Apart from the said documentation, there is no change of ownership of the suit property, and the character of the suit property is not changed. The entire application is moved only with a sheer apprehension on the part of the plaintiff. Stopped. Thank you.